Good afternoon and welcome to AAAED's listening session for OCR's proposed Title IX regulations. We want to thank you all for providing your comments and your concerns. We have quite a session today and we look forward to your participation as may be appropriate. Today's session will be in listen-only mode. If you have a question or a comment you'd like to share, please feel free to type it in the chat box. It's in the control panel on the right-hand side. It should be on the right hand of your screen. You may have moved that. So I'm going to go ahead and have a few additional comments here. As you know, the American Association for Access, Equity, and Diversity, we were founded in 1974 as the American Association for Affirmative Action. We have over 4 decades of leadership in providing professional training to members, enabling them to be more successful and productive in their careers. AAAED is a 501c6 membership organization, really the oldest or most senior operating association of professionals in the equal opportunity profession, and really is the leader in equal opportunity, affirmative action, and diversity training and advocacy for professionals in higher education, private industry, and government. I want to take this opportunity to let you know of some upcoming events. We always have webinars. We are still fulfilling our 2019 catalog, but these are some that we have coming up. So if you want to click on the link at a given time to check to see what our webinars are, right here on the very top, you can do so. I also want to remind folks that we have upcoming AAAED PDI CAP training in Atlanta, and that is going to be March 11th through the 16th. If you don't have your CAP, this is an opportunity to certainly attend. I was afraid that was going to happen. Okay. And then lastly, I want to remind everyone we have our national conference and annual meeting coming up in Indianapolis. It's June 11th through the 13th. If you've attended our conference before, you know they're more than just a conference. This is a learning experience, opportunity to grow and take this back to your organization. I also want to mention that there are also professional certification opportunities at the conference or just before. That's the senior CAP, Title IX, diversity management, and I do believe, and Rich let me know, Title IX. Are we having Title IX training?
Yes, we are.
Okay, so there's lots of opportunity for certification, and we hope that we will see you all in Atlanta. So I'm going to introduce our president now, Richard Anthony Baker. He's the Assistant Vice Chancellor and Vice President from the Office of Equal Opportunity Services, University of Houston System. Rich, thank you so much. We're happy that you will be moderating our session today. And lastly, I want to mention the session is scheduled for an hour. However, given the number of concerns and questions that have come in, it may go over. So this is being recorded, and it will be made available within 24 hours of today's session. So, Rich, are yours.
Thank you very much, Sandra. Welcome. Good afternoon, everybody. Very excited to host this listening session for our membership with our esteemed speakers and also for your participation. What I'm going to do is quickly go over, provide an introduction to the proposed rules, and then introduce our speakers and then let them go ahead and present the information that you guys tuned in for today. So, Sandra, if you can move on to the next slide, I'll go ahead and begin. As a recap, on November 29, 2018, the U.S. Department of Education's Office for Civil Rights, hereinafter OCR, released its proposed guidance for how educational institutions that receive federal financial assistance should respond to reports or complaints of sexual harassment and assault. According to Secretary Betsy DeVos, The process and purpose for creating these proposed rules were to ensure that every student can learn in a safe and nurturing environment, that every survivor of sexual violence must be taken seriously, and that every student accused of sexual misconduct must know that guilt is not predetermined. From her comments, it appears that the fix that the Secretary was hoping to create with this guidance is that one that punishes those that perpetrate sexual harassment and violence while ensuring that a fair grievance process gets us to that conclusion. Sandy, if you can move on to the next slide. So to get us there, for the sake of our discussion, AAAED will cover the major contents of OCR's Notice of Proposed Rulemaking, which includes the following. Schools would be required to respond meaningfully to every known report of sexual harassment and to investigate every formal complaint. The proposed rule highlights that the importance of supportive measures designed to preserve and restore a student's access to school's education program or activity with or without a formal complaint. Those supportive measures may include academic course adjustments, counseling, no contact orders, dorm room reassignments, leaves of absence, or class schedule changes, and other supportive measures. Sandra, if you can move to the next slide. The proposed rule requires that when there has been a finding of responsibility, the school must provide remedies for the survivor to restore or preserve access to the school's education program or activity. However, to get to that finding, the proposed rule will require that schools apply what OCR believes are basic due process protections, including a presumption of innocence throughout the grievance process. In fact, they state that you have to provide this notice to respondents, along with written notice of the allegations and an equal opportunity to review all evidence collected, and the right to cross-examination by both parties subject to rape shield protections. Another significant change from previous guidance is that colleges and universities would be required to hold a live hearing where cross-examination would be conducted through the parties' advisors that the university will have to provide if the parties do not provide their own. While accommodations could be made to limit confrontation, such as putting the parties in separate rooms during the examination, this proposed rule in particular has created great discussion amongst our members. So, Sandra, please move to the next slide. So further, to promote impartial decisions, schools would be limited in their single investigator or investigator-only model. Basically, you can't rely on single investigator findings. You have to take those to a hearing. Under the proposed rule, if a school chooses to offer an appeal, both parties can appeal. And consistent with U.S. Supreme Court Title IX cases, the proposed rule defines sexual harassment as unwelcome conduct on the basis of sex that is so severe, pervasive, and objectively offensive that it effectively denies a person equal access to the school's education program and activity. The proposed rule adopts the clear definition for sexual assault and includes it in the definition of sexual harassment under Title IX. Now, when we move to the next slide, I wanted to go ahead and emphasize that the complete definition that is proposed by OCR is that a school employee conditioning an educational benefit or service upon a person's participation in unwelcome sexual conduct, which is what we typically call quid pro quo harassment. They limit that to school employees, which is interesting. And unwelcome conduct on the basis of sex that is so severe, pervasive, and bold and objectively offensive that it effectively denies a person equal access to the school's education program or activity. So some institutions have or so severe or pervasive. This basically says and pervasive and objectively offensive. If we could move to the next slide. A school would be obligated when they have actual knowledge of sexual harassment that occurred within the school's education program or activity and against a person in the United States. So some questions have come up regarding study abroad programs, etc., and hopefully we'll have a greater discussion on that later today. Consistent with the U.S. Supreme Court precedent, the proposed regulation would hold a school liable under Title IX only when it is deliberately indifferent to known sexual harassment, meaning its response is clearly unreasonable in light of the known circumstances. So with that, there have been some areas of concern raised with amongst our membership and other organizations, such as the proposed rules are narrow in the definition of sexual harassment, the tightening reporting requirements. Basically, all reports would have to be made to the Title IX coordinator or other official. Again, we'll discuss further later. Relieve colleges of the responsibility to investigate off-campus incidents. Provide schools the flexibility to choose a higher evidentiary standard, clear and convincing being that standard, and establish an appeals process and offers an option for cross-examination. Move to the next slide, please. So feedback for these rules have been mixed. The National Women's Law Center was quoted as saying only the worst cases of sexual harassment would count as sexual harassment. Few school employees would be responsible for addressing sexual harassment, and only a fraction of the online or off-campus sexual harassment would be covered by Title IX. Another organization, the Foundation for Individual Rights in Education, also known as FIRE, stated, while not perfect, the proposed regulations indicate the federal government's recognition that students accused of serious misconduct are entitled to meaningful due process rights. And Jeffrey Nolan, a Title IX lawyer, commented that the requirement of cross-examination could affect the willingness of people to report sexual assault if they picture themselves in a courtroom being yelled at about their sexual history the way that you see on TV. So with that said, what I would like to do is introduce our speakers who will then lead us on how we can interpret this guidance for our own campuses, and also keep in mind that this comment period is open for your comment, and that this organization, the American Association for Access, Equity, and Diversity, will be posting comments by that deadline, which is January 28th, 2019. Our first speaker, I'm delighted to introduce, is Brett Sokolow, the Executive Director of ATIXA, the Association of Title IX Administrators. Brett Sokolow is the CEO of Insurm Group, LLC, a national multidisciplinary risk management consulting and law firm with more than 3,000 education sector clients, 15 executive and support employees, and a roster of 30 attorneys and consultants who are at the forefront of the field in their areas of expertise. Sokolow founded the Insurm Group, LLC, then known as the National Center for Higher Education Risk Management, in 2000. Sokolow is recognized for his national leadership on systems-level solutions for safer schools and campuses, and is widely considered to be one of the foremost Title IX expert in the nation. He has served as an expert witness in more than 50 significant lawsuits affecting college, university, and school liability. In addition to his role in the Insurm Group, Sokolow served as Executive Director of ATIXA from 2012 to 2017, and now serves as President of ATIXA, the Association for Title IX Administrators, the leading industry association for Title IX compliance with over 3,600 active school and college members. Thank you, Brett, for being on the call today. I also want to introduce BC Okubadejo. I've practiced this. Okubadejo, who represents institutions of higher education and business entities in civil rights and employment matters, with a particular focus on matters arising from alleged discrimination on the basis of race, disability, age, religion, and sex, including sexual harassment and sexual violence. She has experienced both as an attorney in private practice and with the U.S. Department of Education's Office of Civil Rights. She advises clients on complying with various federal laws, including the Americans with Disabilities Act, Title VI, Title VII of the Civil Rights Act, Title IX, the Clery Act, the Violence Against Women's Act, FERPA, Section 504, the Rehab Act, and Age Discrimination Act. At the Department of Education, BC was most recently an OCR Supervisory General Attorney, managing civil rights attorneys and equal opportunity specialists who investigated discrimination complaints against educational institutions. Her responsibilities included providing pertinent legal and policy advice to case resolution teams, evaluating discrimination complaints, facilitating early resolution of complaints, and participating in investigations and negotiations to resolve complex civil rights matters. BC oversaw and conducted investigations of complaints alleging violations of Title IX, Title VII, Section 504, AAAED Act, reviewed and revised policies and procedures, and provided technical assistance. in person and by telephone. Again, I want to welcome our two expert speakers. We at the University of Houston had the honor of hosting both within the last few years, and we're excited to have them on the call today. And I believe we're going to start with BC and then move on to Brett following her comments.
Yeah, absolutely. Thanks so much for the introduction and for going over the proposed regulations. Before I talk about a couple of the areas that I thought really stood out in the proposed regs, I just want to remind everyone that these are still at the proposed stage. I know I get lots of panicked calls and people sort of wanting to begin to act on these. We don't yet know what the final regs will look like, and what, if any, changes will be made in response to the comments received, or even what will happen if and when the proposed regs are issued. So we're not sort of at the point where we're actively issuing change to policies based on these. But I was hoping that I could talk with you today about three areas that stood out to me in my reading of the regs. I think there are lots and lots of things that could be talked about. But the first is the definition of sexual harassment that was read earlier. One of the things that was immediately striking to me is how significant this is, in the sense that it simultaneously sort of cuts OCR off at the knees by limiting the scope of OCR's authority over sexual harassment, and then at the same time limits schools' liability under Title IX by reducing the kinds of conduct that Title IX requires schools to address. And so if you think about the old definition that OCR used, OCR had jurisdiction up until this proposal, and it still does obviously right now, but if these regs were to go into effect as written, there would be a big change. So the OCR's current definition is unwelcome conduct of a sexual nature that's sufficiently serious to deny or limit access to educational programs or activities. So it's a really broad definition that covers a range of conduct, and it covers conduct that's severe or pervasive or persistent. And that's essentially what the use of serious is supposed to signify. The proposed definition now only applies to conduct that is so severe, pervasive, and objectively offensive that it effectively denies equal access to a school's educational program. And then we also have this adoption of the Cleary definition of sexual assault. And these two are really different. The standard under the proposal is much higher. OCR previously looked both subjectively and objectively at the information to make a determination about whether there was a hostile environment. And the signal here is that we're just thinking about whether it's objectively offensive. And the new definition also means that only really severe conduct is going to be required to be subject to Title IX and to fall under these rules. And now that less conduct is proposed to be covered, what will happen? One of the things is that there'll essentially be less OCR oversight of schools. So, which, is both positive and negative. I mean, I think nobody likes to get an OCR complaint, but there sometimes are benefits to OCR involvement in terms of sometimes helping to provide a basis for needed change at an institution. So there'll be much less OCR oversight and sort of interference in school business. And even if a school does get an OCR complaint, it's now much easier to defend against that complaint, because a school is only liable if it is deliberately indifferent. So a school can offer a student counseling, an opportunity to change courses. Essentially, it sounds almost like if a school doesn't do nothing, then it's very difficult to be found in violation of Title IX. And one of the questions that has come up is, will schools just sort of stop investigating the sexual harassment claims that fall short of this much higher definition? And that seems highly unlikely. It seems much more likely that what we're going to see is an increased burden on the student conduct process, that many of these types of issues will then get pushed. Maybe there is a sort of less serious groping case or a verbal case. Those cases might now become more student conduct cases rather than cases handled under the Title IX policy, which means that those cases will not get the same types of procedural protections that historically they've received. And we can definitely talk more about that in response to questions and other issues that come up. The other area that I wanted to touch upon briefly is the live hearing requirement. And Brett will talk more about this and how it may impact complainants, but I think this is one of the more startling aspects of the proposed regulations. It's a lot more prescriptive than what we've seen from OCR. Historically, OCR has given a fair amount of deference to the sound educational judgment of schools, and now, and especially for private schools that aren't subject to the constitutional due process protections in the same way that public schools are, to see this type of live hearing requirement it really stands out, I think. And one of the ways in which it stands out is that it is not immediately clear how OCR has the authority to require a live hearing, in the sense that the tie to sex discrimination is not immediately apparent. So under Title IX, the Secretary of Education has the authority to issue regulations relating to sex discrimination. But the live hearing requirement here is supposed to be sort of to satisfy due process concerns and level the playing field for respondents. But since respondents can be any gender, and respondents, at least at this stage, are not the ones alleging that they are being discriminated against, at least in terms of on the basis of sex, in terms of the actual underlying complaint being investigated, it's not clear how the department can make schools have this type of process if it's not something that they are interested in doing. And it's also unclear how many smaller schools are going to be able to afford to move away from the single investigator model. As you can imagine, this live hearing requirement comes with many increased costs. So there will be increased costs related to training of additional staff on campus, because if you cannot have the same person conduct the investigation and be the decision maker, those are two sets of people on campus or off campus that you're going to have to make sure are trained and are available. There are also some schools many schools are already outsourcing their investigative process. Some may find that they also start to have to outsource the hearing function, which would present an additional expense for schools. Another potential area that could become more expensive is in the area of providing advisors for students. Now schools are required to provide advisors if one student doesn't have one, or if both students don't have one, because the cross-examination has to be conducted by the advisors. If, for example, you have a respondent who is represented by a national attorney, and then you have a complainant to whom you as a school are required to provide an advisor, there's potential liability if the advisors aren't equal. Or, for example, if and I love to read, nothing against librarians, but this is just an example. Imagine, national attorney facing off against your school librarian who has had, half a day of Title IX training. Is this really an equitable process? Does this mean that the school now has to go out and pay for an attorney to represent the complainant in that instance. So there are lots of equity issues that could come up. And then another piece of the hearing requirement is that remote access needs to be provided upon request. And so that could also cause schools who haven't currently put resources into technology to look at whether they have sufficient resources and means to have a remote hearing where both parties can see what's happening in the room where the hearing panel is and can ask questions of the hearing panel either through this technology or directly. And you know, it may not always be adequate to use something like Skype, depending on reliability and connectivity types of issues. Another concern that comes up about the use of advisors to ask questions has to do with the training of those advisors. So there's the proposed regs don't specify how those advisors should be trained. Are the respondents' attorneys required to receive trauma-informed training? What kinds of questions will they be asking the complainant? Will that create inequities in the hearing process? And then how will those be addressed? So those are just some of the issues. Like I said earlier, Brett will talk a little bit about some of the pressure that's put on the various parties to participate in the hearing and how testimony may not be considered if a person does not participate in or does not subject themselves to cross-examination. And then finally, I wanted to touch upon how the proposed regulations could affect policies at various institutions. The department has presented the proposed regulations as a cost savings for schools, but because the proposed regulations are so prescriptive about what must go into a grievance procedure, what must go into the notices that parties receive at the beginning and at the conclusion of the process, how parties must be notified if there is a delay in the process. I mean, the proposed regulations are just incredibly prescriptive in a way that we haven't seen from OCR before, and essentially mean that virtually every school in the country that receives federal financial assistance from the department, so almost every school in America will have to review and update its policies and procedures and documents related to the Title IX process in order to comply with these new requirements should they become effective. And for some schools, as you all know even better than I do, the process for updating and changing policies can be incredibly burdensome and incredibly lengthy and very expensive, and often requires review by inside and outside counsel, weigh in from various groups on campus under shared governance models, and can be incredibly complicated to implement. Some of the types of changes that would need to be made would include changes to the definitions of covered conduct, because as drafted, there are lots of policies now that cover conduct that doesn't rise to the level of the new definition of sexual harassment. So schools would have to figure out what conduct remains covered by Title IX, what conduct is no longer covered by Title IX, where to put the new conduct, if anywhere at all, and how to address the relationship between the Title IX and the student conduct offices. Schools would also have to do things like include language around the presumption of innocence. Schools that used a single investigator model would have a wholesale procedural change to their policies. The format for reports would have to be reviewed, because that's also one of the things that OCR prescribes. And all these written communications to parties would also have to be reviewed. Schools that don't have evaluation processes at the beginning of their Title IX process to determine which cases move forward and how they move forward and how to refer to other offices would have to implement those types of changes within their policies. And we potentially could end up in sort of a pre-2011 Dear Colleague letter situation where conduct processes are increasingly used to resolve sexual misconduct matters without procedural protections for students. So there would be some losses there. And then we'd also potentially end up in a situation where there are multiple policies required to comply with various laws that address sex discrimination. So there might be, for example, a Title IX policy, there might be a Clery policy, there might be a conduct policy, and then there also might be a policy that addresses other kinds of gender-based discrimination, which, as we learned previously, can be really, really confusing for people who have experienced trauma, for respondents who are struggling to understand exactly which rules apply and how to defend themselves, and just don't always present the clearest approach. So I'll pause there and hand over to Brett, who'll talk about a few other areas before we go more specifically into questions.
Thank you so much, BC. You are a hard act to follow. The best I may be able to do is to avoid traumatizing all of the librarians who are on our call today. But thank you for such a comprehensive review of what we're facing with the proposed regulations. I want to thank Shirley and the association for inviting me to be a co-presenter today. It's always nice when our associations are able to collaborate on such an important topic like this, and I'm happy to talk to all of your members, and I know we have overlapping members, so hello to all of the ATIXA peeps who are presenting or participating today, and to Dr. Baker for setting us up with great information about the proposed regulations as we enter into the conversation today. Given the specificity of what you just heard, I want to really confine my comments to some overarching themes and specific ways that you can make your comments known to the Department of Education and really make them count. And so you may hear a bit of an advocacy voice in the approach that I take to this, and feel free, of course, to have your own thoughts and approach this from whatever perspective you choose to, not necessarily mine or ATIXA's, but I do want to let you know, where I view things as far as this process is concerned, and hopefully some of the things that I'll say today are provocative and cause you to frame your comments to the Department of Education accordingly. First of all, I hope all of you will comment. We have until the 28th of January to do so. For any of you who are looking for official comment from ATIXA, we will be hosting similar sessions with our members next week. Thereafter, we'll be finalizing our comments. We will post those publicly by the 19th, so that those of you who wish to use those comments as a template to build upon for your own comments, you'll be able to do so. I strongly encourage you, though, not to just take the comments of any other organization and copy them and submit them to the Department of Education. You want to make sure you customize them. You want to make sure you make points that are specific to your campus, your school district, your community, or your organization. And importantly, we want to vary the comments. They've already received 51,000, and we're already preparing well over 30 pages of comments from ATIXA. You want to make sure that your comments vary enough that we push the Department of Education to respond to each and every one of them. And while that may slow the regulatory process to some extent, it may take them quite a while to respond to comments, they aggregate the comments and put them into categories and respond to them categorically. So the more varied comments you have, the more categories they have to respond to. And you're not engaged in a process when you make these comments that is futile. In other words, I don't expect the Department of Education will be dramatically influenced by the comments that we make. There may be some changes to the final regulations versus the proposed regulations that we've all seen at this point. I do anticipate there will be some, but by and large, the comments that we make lay the foundation for challenges to those regulations going forward. And when we were talking in preparation for today's presentation, I think we had a consensus that the one thing we know will come out of the new regulations once they take effect is a good decade of litigation over the substance of the regulations themselves, the authority of OCR to implement them, the ways they impact on colleges and schools. And so unfortunately, and I know many of you look at these changes with trepidation, those of us who look at this from the perspective of litigation see quite a future of controversy over the changes the department is making. I think BC put it well when she talked about the idea that the department is becoming prescriptive. I would say to the point of potentially bullying funding recipients in terms of the requirements that are being proposed. And when the Department of Education responds to these comments, which they must do when they publish the final regulations, the substance of those comments provides the fodder for the litigation that will follow. If the Department of Education defends its position well, then it will be in a position in litigation if challenged to defend the scope of the regulations and the Department of Education's authority to implement them. But if the Department of Education fails to make an adequate case for its authority or for considering all perspectives or for addressing the comments, they leave themselves vulnerable to legal challenge that they acted outside of the scope of the statute or outside of the authority of the agency or in an arbitrary or capricious manner. And there are many ways to challenge these kinds of regulations, especially given the scope and prescriptiveness that the Department of Education seems to want to engage in. And so for many of us, we will move into alignment with these regulations. ATIXA is already preparing model policies to help our members to do so. But there are also a lot of institutions out there that I think will probably choose to be holdouts and will implement some of the requirements, but not all, or push back against others. There are many private colleges, for example, that I'm hearing from that don't believe the Department of Education has the right to require them to provide live hearings. Public institutions, perhaps that's a different argument, but for private institutions, they're wondering how on earth the Department of Education within the scope of the Title IX statute can require that. And there may be organizations or institutions that wish to challenge that. So one of the things they'll have to think about is whether they wish to challenge it from a perspective of compliance. We're doing it, but we really don't think we have to, or from the perspective of refusing to comply, seeing if the Department of Education attempts to enforce upon that, and then doing battle in court over whether the department has the authority to enforce on that basis. The department is in some ways playing very high stakes poker here in risking its authority and subjecting it to court oversight on the basis of what could be very, very substantial overreach. And so these comments are essential because they will lay the foundation, your questions, along with challenges, along with the Department of Education's responses to whether the department's actions are defensible. And there'll be Administrative Procedures Act attempts to overturn some or all of the regulations. I anticipate there are a number of organizations that will attempt to enjoin the regulations themselves as applied to various situations, either as they're being proposed or once they are finally published. Already we're seeing respondents who are looking to enjoin their campus proceedings now because they argue that within a few months or whatever the timeline might be for final publication, they'll be far better protected by the upcoming regulations than they are by their college or school's existing policies and procedures, and they wish to enjoin the existing procedures application until those better and stronger protections are put in place by the Department of Education. We'll see, I think, a good bit of that kind of litigation going forward. I think that we're going to see a good bit of litigation over what are essentially effective assistance of counsel claims, because we are entering into a sphere where colleges and schools will be providing advisors to students and employees who are going through the process. And if those advisors are well trained and they do their job well, then they probably won't open their employers up to liability. But if they give bad advice or they fail to provide the same level of competent counsel that perhaps that attorney on the other side, as BC mentioned, is providing, then you could see the student or employee attacking the institution for providing ineffective advisors, ineffective assistance. And I think those lawsuits will be quite voluminous. And then I think we'll also probably see a rise in challenges by complainants or alleged victims, whatever terminology that you wish to use. At ATIXA, we call them reporting parties, just a neutral term. But I think that there'll be a renewal of litigation and activism by those who are on the receiving end of sex and gender-based discrimination, and attempts to hold both the Department of Education and funding recipients more accountable. For those of you who are observers of the content and substance of the proposed regulations, I don't think it's hard to see that the pendulum is intentionally being swung by the Department of Education toward responding parties. And anytime the government takes a position of favoritism, you can expect that those who are on the short end of that stick to renew their activism and their challenges to the partisanship that they're facing from entities that are supposed to be neutrally protecting all of our citizens and all of our members of our school and college communities. There is no question in my mind, again, this is just my personal and professional opinion, and it may not be shared by others, that at a time when the best move from the Department of Education would have been tweaks and minor revisions to the 2011 and 2014 guidance that we had received from the department. Certainly we need to shore up due process protections and other procedural areas of fairness to all parties, that we didn't need to throw the baby out with the bathwater and to get rid of the 2011 and 2014 guidance to replace it with something as broad spanning and amazingly really far-reaching as the proposed regulations, really for the first time in 40 years, re-regulating on Title IX, is going to swing the pendulum too far in the opposite direction. And there are those who would argue that the Obama administration swung the pendulum too far toward reporting parties. I'm not so sure that I agree with that analysis, but I think we can all agree that the pendulum swung too far, regardless of what caused that to happen, and that we needed to reassert better balance. Unfortunately, the political process that has taken place means that rather than swinging within a relatively narrow range of good practice and industry standards, that we're going to ping from one extreme to the other. And these new regulations are going to take things so far off the deep end toward protection of responding parties that it will likely engender an entire generation of activism, given the Me Too movement and everything else that's happening within our society right now, by those who are going to be perceiving the Department of Education is taking sides, and taking sides against victims, taking sides against those who Title IX was originally intended to best protect. And so we had overreach that I think is very clearly demonstrated in a number of the provisions of the proposed regulations. And I'll go so far as to say that I think that a lot of these provisions will function as a potential poison pill for the willingness of those who are impacted by discrimination within our communities to potentially come forward and to access our remedial apparatuses and our resolution mechanisms. And I have great concern about that, worry about that. I know Bisi sounded that theme a little bit as well, but it's bearing on my mind quite a bit recently, from provisions that require written notice to narrowing who can provide notice on behalf of the institution, to provisions that require full sharing of all information. And I'm a fan of sharing information with the parties prior to a decision, but to share even information that the institution intends not to use, to provisions that subject parties to live hearings and cross-examination by third parties who could be very well-trained attorneys. I think all of that will be very intimidating. And my fear is that it will result in a chilling effect on the willingness of those who are impacted by discrimination to come forward and to seek redress. And so one of the themes that I hope you will be able to sound in your comments to the NPRM is about that chilling effect, the obligation of the Department of Education to protect everyone who is supposed to be protected by the Title IX statute, and the ways in which our institutions need to continue to serve those populations who are being excluded because of sex or gender from program participation, benefits, or opportunities. So from where I sit, I think the best approach for us to take institutionally going forward, shifting from comments about the comments we make to the department, from what do we do with these regulations once we're saddled with them, is to view them as a floor, is to realize that the Department of Education is largely talking in these proposed regulations about the way that it will enforce upon colleges and schools, that it is not requiring us to use particular definitions, procedures per se, except as a floor. And that in each and every instance where we have the opportunity, we want to exceed that floor. We want to achieve best practices. We want to meet industry standards. We want to do the things that do right by the members of our community, regardless of how low the Department of Education sets the floor. And as my team at ATIXA has reviewed the proposed regulations, and again, things could change before final publication, we think there are a lot of areas where we will have latitude to move well beyond the floor the Department of Education is setting. But when I talk about the department bullying us, they've phrased it in a way that makes it sound and feel like we can't exceed the floor or we can't depart from the regulatory approach that they're taking. And I don't think that's the case in any way, shape, or form. So just to use the example of jurisdiction, the Department of Education seems to be saying that when behaviors occur off campus and they don't fall within the definitions within the regulations, that we have to dismiss the proceedings. And that's in some ways either trickery or sleight of hand. I'll just use the phrase bullying because I think it's appropriate, to obfuscate the reality, which is that we can take off-campus jurisdiction if we choose to. We have to have clear policies and procedures that allow us to do it. The Department of Education is just saying that it won't enforce on off-campus incidents, which is fine, but that doesn't limit our ability to address the wider scope of behaviors that impact on our community or behaviors that happen off campus that have on-campus impacts. And so we have to frame our policies and procedures carefully to give us this authority. If the Department of Education is making it look like they are trying to take it away, or they say things like, well, we have to dismiss a complaint if it doesn't fall within the scope of policy under Title IX. Well, that's true, but that doesn't mean we have to take it through the student conduct process or no process at all. It just means we have to have a broad sexual misconduct and non-discrimination policy that isn't a Title IX policy. What doesn't fall within Title IX can still fall within prescribed behaviors by a school district or a college or university, and we can take it through the very same protections that we provide to someone under Title IX or any other anti-discrimination statute or protection. And so I think the department is really trying to make it seem that they are confining us. And there are some ways that, of course, they're trying to, for instance, with live hearings, but there are other ways that I don't think they really can do so, even within the scope of the proposed language that they have put forward. To talk a little bit about the live hearings and the cross-examination requirements, and this will really sort of round out my comments before we turn to all of you for your thoughts and questions. We do have a sea change in the sense that the department is going to require live hearings. And this will largely do away with the single investigator model, though I don't think any school should have been using the single investigator model to begin with. We always should have had some separation of investigation and decision making, even if it was an appeal step of some kind. And so now the department seeks to move us to live hearings. And as I said before, there will be challenges to that. So who knows whether a few years down the road, some court will even overturn that requirement, but we seem to have that requirement in the Sixth Circuit now, at least, and perhaps even in the Ninth, depending on how you look at it. And so the courts are moving to some extent in the same direction as the Department of Education seems to be moving. And so we will have to get good at live hearings again and at training our hearing chairs and making sure they're very clear on our procedures and making sure they're very cogent on evidentiary rulings, whatever rules we have in place with respect to past sexual history and hearsay and whatever else it might be. And again, I don't think that any of us want to turn the campus or school process into the equivalent of a mini courtroom, but it does seem like the regulations are intent upon doing so in the interest of protecting due process. But a lot of what you'll see challenged in the comments and challenged with the litigation going forward is what basis the Department of Education has to regulate on due process at all. There's nothing within the statute that mentions due process. There's nothing inherent within the statute that would give the department authority to address due process. They try and argue in the proposed regulations that it is inherent within the equity mandate, but it really isn't. So attack that with your comments if you see fit to do so, for the very reasons that BC just outlined, which is that equity is about whether you are showing preference or detriment on the basis of sex or gender, not to whether you have a disparity in your process as to complainants and respondents, because of course complainants and respondents can be of any gender or identity. And so there's nothing inherent within that construct that gives the Department of Education authority. And I think we want to push back as much as we can on turning the proceedings into mini courtrooms. At the same time, we're going to have to sharpen our pencils and get much better at running live hearings and making sure that we're providing adequate protections. The one area that I think is probably going to be of greatest vulnerability and controversy going forward is this cross-examination requirement, where the Department of Education has said that cross-examination is required, that the parties can't be adversarial toward each other directly, but will do so through their representatives, who are advisors that they either choose or hire. Those advisors can be attorneys. And so we want to be very clear in policy and procedure going forward. What is the role of that advisor in the pre-hearing process? What is their role in the hearing process? What are rules governing the kinds of questions they ask? Who makes a ruling on whether or not the questions are appropriate or need to be reframed? There are requirements within the regulations that require the school to explain any questions that aren't going to be posed and why we're not allowing that to happen. And then we also have to have some default rules. What happens if a party doesn't choose an advisor? Will the questions go through the panel? How is that all intended to work? And then there's also a poison pill provision, which probably you're familiar with, that says that if the parties don't participate in the hearing, we can't use any of the information they've submitted prior to that point. And so we have to be able to train our panels or our hearing officers, and we can use a panel or a single officer on what the implications of that are and how that will affect evidence and evaluation of credibility. So there's a ton more that we could be talking about. As you know, the regulations are quite extensive, but at this point I want to confine my comments to the ideas that I've shared thus far and open the forum for all of you to weigh in, to share your thoughts, questions that you have. BC and I are obviously happy to field those questions and help you frame your thoughts and comments as you prepare them before the January 28th deadline. Thanks again for the opportunity to weigh in, and I look forward to interacting with you all.
Thank you very much, Brett and BC, for your comments. Sandra, I know we've received some comments already. Do you mind reading some of those questions now?
Okay. The first question: it is clear that under the proposed rule changes, neither the Title IX coordinator nor the investigator can act as the hearing officer. But can one person still act as the Title IX coordinator and investigator?
Yeah, I'll start it off. I don't see anything in the regulations that would overtly prohibit the long-standing position the department has had, which is that the coordinator and the investigator can be the same individual in a situation where there are resource limitations or not enough personnel to go around. But we have to be careful of a couple of things within the regulations and within best practice in the field. If the coordinator and the investigator are going to be combined into one function in any given case, we have to still avoid conflicts of interest. And we have to make sure that as the process unfolds, that individuals are not wearing multiple hats that undermine the presumption of innocence that the Department of Education now seeks to codify, or that creates in any way a lack of independence for the decision makers who are subsequent to the investigation and the process. So, for example, if your coordinator and your investigator are the same person in a given case, I wouldn't want your single hearing officer, if there was a hearing officer who was the decision maker subsequent to the investigation, to be somebody who reports to the Title IX coordinator, because then somebody is going to argue later on that somehow that wasn't an independent determination. So it's not a practice that I would ever prefer, but I certainly understand that there are very small schools and colleges, very resource limited institutions, where the coordinator and investigator are always combined functions. And now we'll have to add a hearing officer, which adds another responsibility. One of the other questions will be, do we need to add a chair? Who is the chair of the hearing, who's a procedural officer, who's separate from the hearing officer? Or can we combine the hearing officer with the chair? All of that adds resources. All of that adds time. It adds expense. And many institutions aren't going to be able to budget for that. So we have to work within reality. And at the same time, we also have to realize that the Department of Education is saying two contradictory things at once. One, you have to comply with these high standards, but two, we're not going to police you all that intently if you don't. So, that will all come out in the wash as we figure out how much the Department of Education intends to oversee schools going forward who don't meet every letter of the standards. But think about it. Could we argue to the department, well, we weren't deliberately indifferent, even if we didn't meet every single obligation that you laid out? I think there's an argument to be made for that. So, again, there's so much here that is yet to be determined that I can't give a definitive response. And if BC sees it a different way, great. But I don't see anything in the proposed regs that would prohibit that overtly.
Yeah, I agree. I don't read the proposed regs to prevent that from happening. I do, like you, share concern about potential conflict of interest. I know there's been some litigation on this point around coordinators whose communications with one or both parties have raised questions about whether they truly were neutral in the process. So I think there are challenges in using a structure like that, but obviously sometimes we are resource limited and just do the best we can to minimize the conflict of interest issue.
Thank you for that response. Sandra, if you would please, could you give our listeners the instructions again to send you any comments that they would like BC or Brett to answer during this call? And after you do that, ask our next question.
All right. If you have a question, please put it in the chat box, and we will certainly announce your question. If you have raised your hand, we have one. If you could type your question in the chat box, that would be greatly appreciated. Okay, in the meantime, I'm going to go on to the next one here. How will the proposed rulemaking impact mandated reporting?
This is BC. I'll jump in. I think this is one of the areas where there is flexibility in how you structure who is required to report on campus. So if a school, I think, wants to continue to require all employees to be mandated reporters, they can continue to do that. I think where the difference is coming up in the proposed regs is the instances where you would be required by Title IX to respond to a report. So you wouldn't have to respond to a report unless, there were a formal complaint and you had this formal written complaint made to somebody who has the authority to address the underlying conduct. So you could, if you wanted to, very narrowly limit who your mandated reporters are if you haven't already done so. But I think many institutions probably will continue to have a broader range of employees on campus who are designated as mandatory reporters out of an interest in ensuring that the campus remains safe. And obviously this is different from the Clery obligations, which could also impact, how people are designated on campus.
Yeah, I come back to the theme here that this is a floor, and the department is now setting a very, very low floor for who must report, but that our job as institutions is to aim for the ceiling and to try as best we can to achieve the practice that best supports and sustains our organizational communities. And so I'm a big fan of the if it isn't broken, don't fix it approach to risk management. And if your organization or district or institution finds that your current definitions of mandated reporters, which are likely broad, most institutions are serving your institution well. They're not chilling victims off from coming forward. They're providing a safety net, a no wrong doors approach, that you have plenty of confidential advisors designated, and you have counselors and others who are not mandated reporters carved out. If it's working for you, this is not an opportunity to change anything. I'm always afraid when the Department of Education provides guidance or regulations that we tend to just work within the four corners of that box rather than asking the question, what should we be really doing here to best serve our constituents? And so for me, the whole movement, and ATIXA was part of that, toward declaring the majority of our employees to be mandated reporters, made a lot of sense and still does in my mind, given obligations to report that are imposed by Title VII, by the Clery Act, as BC just mentioned, not just by Title IX, because of what we're trying to establish within our communities as a culture of caring with our behavioral intervention and threat assessment teams. When we see something, we say something. That's the kind of engaged, non-bystander community that we're trying to be. Why undermine all of that effort because the Department of Education is going in a different direction that could be overturned the next time there's a presidential election? So from my view on that, if the structure isn't working for your institution, then you want to revisit it, right? There are certain, especially very small schools, that have always used faculty, for example, as a safety net for people to come forward and report to. And if you take away that opportunity by making faculty mandated reporters and you don't replace it with a very clear mechanism for safe, harbor and reporting under safe circumstances, then you could have a chilling effect on reporting, and maybe it's worth examining whether all faculty, for example, should be mandated reporters within the existing framework. So I never want to approach this from a one-size-fits-all, but I think for most institutions, we are concerned about the risk management issue of trying to tell some of our employees that they're mandated under Clery, but they're not mandated under 9, but they are required under 7 because they're supervisors, and trying to get them to keep that all straight. That's why we came up with a mandated reporter construct to begin with, was to say, look, rather than trying to meet the letter of each of these competing laws, let's just have one size fits all in the sense of one rule so that employees can navigate clearly and know what the expectations of the institution are. And I still think that's a compelling argument.
Okay, question. Thank you both for your response there. I'm very concerned about the time frame for implementation. I mean, these are proposed regs. Nothing's been finalized yet.
You want me to take that one? I'll start. Yeah, we don't know timeframes. What I do know, and it could change, is that they do intend to start enforcing the new rules within 30 days after publication in the Federal Register. What we have no idea is how long it's going to take them to publish in the Federal Register. Let's assume by the end of the month they could be facing somewhere between 70,000 and 100,000 different comments, which realistically they could. And they've got to respond to all of those. I don't know what kind of staff they're able to put on this right now, but I know that the department is much scaled back from the way they were staffed during the Obama administration, that they have not filled a lot of positions of people who left. And The best bellwether I think we have is that when the Department of Education issued the Dear Colleague letter in April of 2011, they then solicited the field to an extent for questions that became the basis of their Q&A document that was released in April of 2014. It took them almost 3 years to get through what was about 1,400 comments that they received at the time and respond to those with a 50-some-odd page Q&A response document. So if the Department of Education is continuing to move at that pace, and frankly, the proposed regulations took them a lot longer to publish than they said they would, so there's nothing that indicates to me that they're moving with any alacrity here. It's entirely possible that Congress could act, or that the presidential election of 2020 could occur before they ever get their acts together enough to get the new rules out. Now, I know they'll be pushing really hard to move as fast as they can, given the possibility that that could happen. They're going to want to get these new rules in place before there's potential regime change in Washington in 2020. But I don't know how fast they can move. Maybe Bisi's got better insight into this because she's been inside that agency. But to me, this feels like a 12 to 18 month window from here, and that's just based on every regulatory cycle I've ever seen before. Maybe they'll be capable of pulling off a miracle, but I wouldn't bet on it.
Yeah, I think it's going to take the department some time to get through all the comments. I know they're starting to look at them. I know some of the people whose job has shifted to reading some of the comments, and it's a heavy lift, and it will be some time before the department can get through all of this. And I'm not sure anyone really knows how long it will take. Even the secretary might have a wish for a time frame. I think the best we can hope for is that the publication is timed so that it doesn't happen, in the middle of a semester, or, at a time when we're all incredibly busy, and then now find ourselves having to completely shift gears. But I think we're still some time away from implementation.
I mean, and if they were wise, and maybe you can include this as part of your comments for all of you who are listening in today, they'd probably issue them at the end of May and give us through the summer to get policies and procedures up to speed so that we could release them in August, right? The department doesn't tend to work on a college or school schedule, but from the perspective of those of us who write and implement policies, we'd be lucky if we had a final version in May to get everything that we needed in place by the following August. So this is a time to also begin thinking internally about how long it took us to get up to speed on the Dear Colleague letter in 2011. There were many institutions that hadn't made needed changes by 2013, 14, sometimes even 15, because we couldn't move institutionally that quickly through shared governance and decision-making processes. Well, that's not going to fly this time around. And so this is not new sub-regulatory guidance that you can decide to take with a grain of salt. This is regulation with the force of law, enforceable within 30 days of publication. And that's why I keep saying to all of our members, we need to start preparing for this now, not waiting around until all of this comes to pass, whenever it may come to pass.
I have a question for you too. So one is a question regarding actual knowledge. So based on the proposed guidance, basically, if the Title IX coordinator or another designated official doesn't receive the report, then the institution doesn't have actual knowledge of a Title IX situation, which basically means like a situation like Penn State or Baylor, if the coaches never responded or reported to the Title IX coordinator or other designated official, then the institution couldn't be found in violation of Title IX because they didn't receive actual knowledge. Wanted to get your feedback on that. And the second is more of a jurisdictional issue. So the question, or does conduct occurring on the way to class fall within the program and activity requirement? Or said another way, does conduct occurring after class, for example, online harassment, which we're all familiar with, would that be considered a program or activity requirement?
Sure. So I can start with the actual knowledge piece. The proposed regs explain that actual notice means that you have notice of sexual harassment, and that notice is given to the Title IX coordinator or any official of the institution who has the authority to institute corrective measures on behalf of the institution. So that is actual knowledge. I mean, it's much, much narrower, and I think it does shift in terms of liability or responsibility under Title IX, what schools have to worry about. But that being said, schools may have obligations under other statutes. So you may have other federal statutes like the Clery Act. You may have Title VII obligations. You may have your state and local laws, Non-Discrimination and Human Rights Acts, that require you to take action even if your Title IX policy does not.
Yeah, I generally agree with that. I mean, I think we've got to be careful in all of this to realize that OCR is not the end-all be-all on this as well, that there are court standards that we're going to need to continue to adhere to, whether they match with OCR standards or not, some of which continue to evolve and will continue to evolve post-OCR regulation on all of this. And maybe those court standards will be influenced by the regulations because courts generally show some level of deference to agency regulations on this. But, you know, if the court looks more broadly at the issue of notice and some will and some won't, how could that impact on the narrow definition that OCR is offering? It's worth thinking about. I think in this respect, the OCR definition reasonably aligns with Davis and the Supreme Court, and so it's unlikely that there'll be huge daylight between the OCR standard and the way courts would enforce. But there's no guarantee, and as Beezy said, there can also be interplay of state laws that are in play. With respect to sort of program periphery behaviors, as I like to call it, things that happen on the way to and from school, that happen in online programs or even social media exchanges between students outside of school. I think the best practice is going to be for us to establish by policy what we want to address, not necessarily to look to the law as anything but a floor on this, as I mentioned already. But if you're interested in what the floor looks like, if you have behaviors that occur on a college campus heading to and from class, that's certainly going to be enough to fall within the educational program definition of Title IX. But if you have behaviors that occur between two students who are walking to their high school and they're on private property at the time, although they're headed to class, and it has really nothing to do with an educational program's federal funding, then I think you could carve that out of Title IX's jurisdiction. And while a school might want to address it discretionarily, would not be obligated to do so legally. With respect to online behaviors, it gets more complex. Is the online forum one that is sponsored by the funding recipient? Is it an online course or a discussion session or something that is somehow run within the institution's program or umbrella? If so, I would argue that Title IX is going to apply to that. But if it's something that just involves two students or two employees and happens to be taking place on social media, then we want to look to the line of cases that's developing that is really limiting the ability of institutions to address purely off-campus speech. I'm talking about public institutions, right? Because it becomes a First Amendment issue at that point. But there's a whole line of cases, Blue Mountain, Layshock, Hermitage, various jurisdictions that say that unless purely off-campus speech occurs through a school's network or causes a very substantial in-school disruption, programmatic, mission-based disruption, that for a school to try to address that off-campus speech would be a violation of the First Amendment rights of the speakers. So I think with a limitation like that in place, it's easy to argue that if the First Amendment protects the speech, Title IX isn't going to allow you to discipline. That doesn't mean we don't look to remedy and address the behaviors, right? We know now the Fourth Circuit just came out with a case that says we still have to look to potential remedies in addressing things like online gossip sites and ways that students are harassed through online mechanisms that can be accessed on campus, and we can geo-block and cache these sorts of things and address the behaviors, and we can't ignore it, but we may have limitations both technologically and practically in what we can do.
Okay, so we have another question. Does an advocate necessarily mean we need to provide legal counsel for parties?
No, I don't read the regulations to say that a school has to ensure that a lawyer is provided. You simply need to make sure that there is an advisor provided whose interests are aligned with the party whom they're advising. So if you were providing an advisor for a complainant, it would be somebody who would be aligned with the complainant's interests and able to represent those interests, and the same for the respondent. I think that the challenge is sort of one of the challenges rather, is the issue we discussed earlier around equity of the advisors. Are they sort of equally skilled and experienced? What happens if an advisor provided by an institution makes a mistake that is outcome changing for either party? Is that person or is the institution now subject to liability for that? I think there are those types of issues, but I don't read the regulations to say that you have to provide an actual attorney. I know that there are some states now that are trending in that direction to say you actually have to provide an attorney for the parties, but that's not how I read the proposed regs.
Yeah, I don't disagree with that analysis. I just think that the practical reality as we go forward with this some years down the road, if it survives into the final regs, may be taking us in exactly that direction. So there's the literal read of what the regs say, and then there's the practical implication of it. I imagine a situation, for example, where a responding party is facing a serious allegation and needs to make a determination. Do I subject myself to this process, or do I withdraw and go to school somewhere else if it's a college? And while an attorney is well positioned to advise a student, let's say it's a student, on a question like that, an institution's internal advisor, who's a process advisor, is really well trained to advise the student on the process, not whether they should remove themselves from the process. And I think you're going to find a tremendous amount of litigation around that. I also think you're going to find a tremendous amount of socioeconomic imbalance. And I don't have a particular way to explain this, but in my experience, I've dealt with thousands of cases. For whatever reason, responding parties seem to be better able or motivated to afford good counsel than reporting parties who maybe just don't know they need it or don't want to tell their parents what's happened to them, or for whatever reason are socioeconomically less able. And I think you're going to see those disparities come into play as an institutional issue, where victims are saying, look, we'd love to have attorneys in the process. We can't get them. We can't afford them. Whatever factors are a barrier. What are you going to do about that? And so I think, to be realistic about this, state legislatures will likely step in. I think you're going to see this is a first step, especially if Republicans maintain political power over time, a first step toward moving toward a full adversarial hearing with lawyers doing battle on behalf of their clients. I think this is just the opening of what will eventually become a floodgate.
Okay, here's another question. If our Title IX office is separate from our student conduct office, can investigations and hearings still be coordinated by the Title IX office, or does this now need to occur in the student conduct?
So I'll jump in and answer that one. I don't think there's any restriction in the proposed regulations on that particular point. I think the Title IX office can continue to coordinate Title IX investigations if that is the model that a particular institution has. I think there are obviously lots of additional requirements around what that process will look like, and there'd need to be some changes procedurally, and there'd also be a need for increased coordination between the offices, particularly for cases that no longer rise to the level of sexual harassment. But I think one of the things that would need to be decided is sort of what conduct the Title IX office has jurisdiction over and what goes to student conduct. And I think that you need to have really clear conversations about that, because some schools might choose to keep all sexual misconduct cases with Title IX, regardless of whether they fall under the Title IX policy or the student conduct policy if the proposed regs go through as issued. And then there might be others that decide, only the most severe cases get handled by the Title IX office, and then everything else we just treat, as a student conduct matter. But I think that's one of the areas where a school will have the autonomy to decide what its model should look like and what makes sense for its campus community.
Yeah, without disagreeing with any of that, I would simply answer in a different way, which is that if you want to avoid being litigated into oblivion by these changes moving forward, the decision maker, wherever you place that person or panel, ought to simply be the best individuals or group within your organization who are trained and experienced to make good decisions on tough cases like this. I don't particularly care where they live, but they need to have the talent to get it right.
Right. Thank you. Well, we do have a lot of concerns about cross-examination, cost to the institution, certainly the definition, in the change of sexual harassment, and whether or not, these rules are really going to be effective. Any comments on what you believe the effectiveness could possibly be, if it goes forward as written?
Brett, do you mind taking that? There's a little bit of breaking up on my end because I didn't fully hear the question.
Yeah, the question was about effectiveness and whether the regs are going to be effective. I guess the question is, what are they supposed to be effective at doing? If they're supposed to be effective at scaring victims away, I think they could be, unless there's a real mobilization from the grassroots to not let that happen. And I hope survivors will not let that happen. So that that could be very effective depending on what you see as the goal. If the goal is to better air the issues in a forum so that the parties have a full and fair opportunity to fully explore the evidence, I think it can cut both ways. I think that the practices that require us to share all of the information in advance of the hearing are wonderful, right? Parties should have all of that information and be able to share it with their advisors and fully prepare for it. But do I think that once you get into the hearing itself, that airing of those issues with what may be not well trained or lesser skilled advisors, I mean, even some attorneys aren't so great at this, let's be honest, is going to give a better airing of the full issues than a talented investigator who fully explored those issues over weeks in an investigation? No, I don't think that a hearing is better. And I think that the folks who are really strong proponents of respondents' rights, who seem to be celebrating these changes right now, are going to be facing a little bit of be careful what you wish for, because the problem to me is still inherently going to be the bias and lack of impartiality of decision makers, regardless of how the information is aired in front of them in live cross-examination. So it feels a little bit to me like they're trying to solve the right problem with the wrong solution.
Great, thank you. Another concern, what changes to our current policy will be necessary? And will this limit our jurisdiction to investigate allegations of misconduct?
So I think in terms of policy change, there will be a need to look at the existing Title IX policy or sexual misconduct policy to see if, for example, if you have a really broad sexual misconduct policy, is this going to be your Title IX policy, or do you need to create a separate Title IX grievance procedure? If you find that you need to create a separate Title IX grievance procedure, which I think many institutions will find, given the limits to the definition of sexual harassment and the increased burdens and requirements on for addressing claims of sexual harassment, then I think each institution would need to go really, really carefully through whatever the final regs are to pull out each piece of these policy requirements. So, there would need to be required language around the presumption of innocence. There would need to be specificity around notices and timing and each of the prescriptive elements that we've seen in these proposed regs. And I think that is going to be a really thoughtful process. It sounds like Brett said that his organization is putting together some model procedures. I'm sure there will be lots of guides and assistance out there should that time come. But those are some of the types of changes that I would anticipate. And sorry, there was a second part to the question.
Yeah, the jurisdictional question of will this limit an institution's ability to take cases? I don't think so. I think that could be an institution of choice, and the Department of Education would support that choice, but there's nothing within the regulations that's going to require you to take less jurisdiction tomorrow than you take today. You can choose to take broad jurisdiction if you wish to. In terms of the model policies, we've always published models. Our newest version, which in my view is going to be 2019 compliant, although we don't know exactly what the 2019 rules will say yet, but as far as we know, it'll be out within 10 days. It's a 64-page document of policies and procedures, and it's what we needed lengthwise to comply with all the new requirements. So for most institutions, I agree with Lucy, there's going to be a lot of changes. Just the formula alone for disclosing outcomes is complex. So we have an obligation to meet these requirements going forward if we want to exercise the safe harbor that the Department of Education is offering, which is if you follow these, we're not coming after you. So we've tried to put together a reasonable, fail-safe set of policies and procedures that blend both, right? The floor of the law and the ceiling of what should we really be doing to best serve our communities as we look to make our programs as accessible as they can be and to insulate them as much from discrimination as possible.
Yeah, and I think you're right on the jurisdictional point. The proposed regs in a couple of places are specific about the fact that there's nothing in the regs to stop you from addressing conduct that isn't covered by Title IX through student conduct processes or other processes. And so I think many institutions are likely to continue to do that. It's just really a question of what shape that takes, who has authority over it, and there'll be some restructuring and reorganization necessary, and it could be confusing for the community, but it's still possible to continue to address that kind of conduct. It's just given a sort of a more optional feel from OCR's perspective, even though there may be other laws that require you to continue to address that conduct. And also students probably will expect you to do that, as will faculty members.
Well, we're coming to the end of our 90 minutes, and I wanted to take the time to thank our speakers, presenters today. I will tell you, I was greatly enriched by our conversation. Thank you for your insightful commentary and interpretation of these rules. I'm sure that our members have benefited greatly from the information, and again, we appreciate your willingness to share your expertise today. I am hopeful that our members will provide comments if you have suggested. If there's any parting words in this last minute, what do we do within the 18 months that this may take, or they're actually rules that they will be enforcing? Any guidance or suggestion, or anything you're hearing from your own members that Title IX coordinators or people in the equal opportunity professional space at colleges and universities should be doing with their communities at all?
I'll offer one quick parting word, and that is that, while I think the department is overreaching in these regulations, 70, maybe 80% of the due process protections that they're implementing are wise and worthwhile, and protections that the courts are already beginning to require of colleges and schools. And so in a sense, waiting for the regs to come out is not the approach that I would take, because the members of our community need these process protections now. And that's why we're publishing our model ahead of the regulations, because we agree, conceptually with a lot of them. There's some that, again, go too far, but I think that the goal for all of us has to be protection of all members of the community, whether you're complainant or respondent.
Okay, well, thank you once again for participating on this call. Thank you, members, for tuning in to this listening session. We appreciate it. Again, we're looking forward to your comments, your suggestions. If there are comments you would like us to post as an organization by that January 28th deadline, please let us know. And with that, I will go ahead and terminate the call. Again, thank you, BC. Thank you, Brett, for your participation on this listening call today, and our members and myself. Really appreciate it.